Welcome to the Deep Dive. Today we're tackling, well, it's really a legal earthquake out of South Africa. A constitutional court judgment that's doing more than just adjusting labor law. It's fundamentally reshaping ideas about family and caregiving in the workplace. Our mission today is to unpack the implications of the October 3, 2025 ruling on parental leave. This wasn't just a suggestion, was it? The court declared parts of existing laws unconstitutional. That forces a pretty massive and immediate shift for how companies support new parents. We want to break down what this means for everyone involved.
It really is groundbreaking. The court went right to the core of social equity here. They examined the existing laws. We're talking mainly about sections of the BCEA, that's the Basic Conditions of Employment Act.
Right, the one covering basic labor standards.
Exactly. And the UIA, the Unemployment Insurance Act, which handles the benefit payments. And they found them, quite simply, discriminatory. The way it was set up before, it heavily favored the biological birth mother. It essentially wrote traditional gender roles into law and, well, funded them. The court called this out as maintaining an unfair hierarchy among parents.
A hierarchy among parents.
Yeah, and this ruling is aimed squarely at dismantling that structure.
That phrase really captures the injustice, doesn't it? It makes you think about everyone pushed aside by the old system. We're talking fathers, obviously, but also same-sex couples, adoptive parents, people using surrogacy. So this isn't just about fairness in a legal sense. It's about saying, look, caregiving is a shared job, a shared responsibility, no matter how your family came together. Okay, before we dive into the new leave amounts and all that, maybe we should touch on the legal side first. This came from the Van Wyck case, right? Van Wyck and others v. Minister of Employment and Labor. For those of us listening who aren't lawyers, why was that case the trigger? What exactly did the court say was wrong with the laws?
Well, what's really interesting is how the court identified the problem. The BCEA and UIA, they were essentially quite narrow. They were designed primarily to accommodate the physiological recovery of the woman who gave birth.
It's the physical healing part.
Exactly. And by focusing only on that, the laws completely fail to acknowledge the other crucial parts. Things like the nurturing needs of the child, which are vital, and the bonding rights of the other parent.
So it was discrimination by what it didn't say, almost?
In a way, yes. Discrimination by omission. The argument was that sidelining fathers or other non-birth parents, just because they didn't physically carry the child, well, that unfairly limited their constitutional rights to family life and equality. The court basically said Parliament hadn't kept up with how families actually live and work today, so intervention was needed.
So the aim wasn't just to, stretch the definition of maternity leave. It was fundamentally about supporting the nurturing role of all parents, making the law reflect that parenting isn't just one person's job anymore.
That's the core idea. It's a recognition of the multifaceted nature of parenting today.
Okay, so the court makes this big ruling, but the actual laws on the books, they haven't been rewritten overnight. Parliament has a job to do now.
That's right. They've been given a deadline 36 months, so 3 years, to formally amend the BCEA and the UIA to fix these constitutional problems. But, and this is crucial, the court knew parents couldn't just wait 3 years.
Right, families are forming now.
Exactly. So they put in place some very powerful interim measures. These are legally binding right now. For employers, these interim rules are effectively the law until Parliament acts.
Okay, let's shift then from the legal reasoning to the practical impact. For people expecting a child or adopting, today, what are the actual numbers? What leave can they take now under these interim rules?
Okay, the big headline numbers for couples where both parents are employed. They are now collectively entitled to 4 months and 10 days of parental leave.
Collectively? So shared between them?
Yes. We're talking about 19 consecutive weeks of protected time off work total for the couple.
19 weeks. Wow.
And that collective part is really the revolutionary bit. It's designed for flexibility. It means the parents themselves can decide how to split it up. Maybe, the birth mother takes the first 12 weeks for recovery and bonding.
And the partner takes the remaining 7 weeks later, or they overlap.
Exactly. They can tailor it. It empowers them to plan based on their own needs, their jobs, their preferences. It's much more individualized.
That flexibility sounds really positive. Equity seems to be the goal. But Thinking practically, most couples work for different companies, right?
Usually, yes.
So how does this collective pot of, what was it, 19 weeks actually get tracked? What stops parent A at company X and parent B at company Y from both accidentally or intentionally claiming the full whack from their employer? That seems like a logistical nightmare.
You've hit on the key administrative challenge right there. And honestly, it's an area that definitely needs more formal guidance, probably through that stakeholder dialogue the court mentioned. Right now, the mechanism relies quite heavily on, well, cooperation and verification between the parties involved,
Meaning?
meaning the employee claiming the leave usually has to provide some kind of proof. Often it's an affidavit or maybe a formal letter from their partner's HR department confirming how the leave is being divided.
So the onus is on the employee and the employers to sort it out.
Pretty much. Under these interim rules, if the companies don't communicate effectively or if the tracking isn't diligent, yes, the system could potentially be misused. The court's immediate fix puts the burden on good faith and verification, but a clearer, perhaps more centralized, legislative solution for confirming apportionment is likely needed down the line.
Okay, that makes sense. It sounds like an area to watch. Now, what about parents going it alone? Or situations where only one parent in the couple is employed?
The judgment specifically addressed that too, again, aiming for fairness across different family setups. If an employee is a single parent, or if they're the only employed parent in the relationship, they are entitled to a minimum of 4 consecutive months of parental leave.
So 16 weeks minimum for them.
Correct. 4 consecutive months. This makes sure that essential period of care is protected, even if there isn't another employed parent to share the leave time with.
That seems vital. It shows the court was thinking about the child's needs first, right?
I think so, yes. It prioritizes the child's right to care. While the law encourages shared responsibility where possible, it avoids penalizing families where, perhaps economically, that shared leave isn't an option.
Right. Now, there was another really interesting piece in the ruling about adoption leave. Before this, there was an age cap, wasn't there? Leave was only for adopting children under 2.
That's right. And that age restriction was specifically challenged.
Why was that considered unconstitutional?
The Constitutional Court saw it as unfair discrimination based purely on the child's age. The argument was pretty straightforward. The need for bonding, for adjustment, for building attachment, that doesn't just disappear once a child turns 2.
No, of course not. You could argue older children need more adjustment time sometime.
Exactly. Think about a 7-year-old, or even a teenager, entering a new family through adoption. They absolutely need dedicated time with their new parents to integrate, build trust, and adjust. Limiting leave only for infants ignored that reality.
So, removing that age cap basically says every adopted child, no matter their age, deserves that focused parental support during the transition.
Precisely. It's a significant affirmation for adoptive families.
It really is. Okay, let's pivot now to what might be the most complex piece of this puzzle: the impact on employers. Companies can't just wait for Parliament. They need to adapt now. What are the immediate action items for them?
The very first thing, and it's non-negotiable, is a major policy overhaul. Companies absolutely must scrub any reference to maternity leave from their policies.
Get rid of the term entirely.
Yes, replace it with parental leave and ensure the policy defines it neutrally. It has to apply equally, clearly, to all employees regardless of gender, sexual orientation, or whether they became a parent through birth, adoption, or surrogacy. And importantly, this needs to be a cultural shift within the company too, not just changing words on paper.
Beyond the policy language itself, what about those administrative headaches we touched on, especially tracking that shared leave? What kind of monitoring or protocols should HR be putting in place right now?
HR needs robust, mandatory verification systems. This isn't optional. They need clear, standard procedures to confirm, firstly, that the employee is entitled to the leave, and secondly, crucially, what portion of that collective 19 weeks they are actually taking.
So, getting paperwork.
Yes. That might involve requiring signed declarations from the employee and their partner, maybe copies of the birth certificate or the final adoption order, and potentially, yes, requesting signed confirmation from the other parent's employer about how the leave is being split.
It sounds quite involved.
It can be. The goal isn't just to prevent accidental overpayment or misuse, though that's part of it. It's also about ensuring the company's own payroll and records are accurate, especially thinking ahead to when the employee might need to claim benefits from the Unemployment Insurance Fund, the UIA.
Ah, right. And that brings us squarely to the money side of things, doesn't it? The UIA. If the UIA currently only covers, what, 17 weeks of paid benefits?
Correct, a maximum of 17 weeks currently.
But this court ruling guarantees the right to 19 weeks off. That's 4 months and 10 days. There's a gap there. What happens in those extra 2 weeks? Who pays?
That is the critical financial point for employers right now. The UIA is the fund that actually pays the benefit money to the employee while they're off. As you said, it currently caps out at 17 weeks. So if a couple decides to take the full 19 weeks of protected leave that the court says they're entitled to.
They've immediately gone past what the UI fund will pay for.
Exactly. Those last 2 weeks, or whatever portion exceeds the UIA maximum coverage, well, that responsibility typically falls back onto the employer.
How so? Does the employer have to pay for those weeks?
Not necessarily mandated by this ruling to pay, but the employee still has the right to be off work. So the employer has to manage it. It might mean those weeks are unpaid leave, or perhaps more likely given workplace expectations and competition for talent. It might mean the employer needs to implement their own policy to top up the leave, essentially paying the employee directly for that period not covered by the UIA.
So, this ruling could effectively create a new potential 2-week financial cost for the employer per family using the full leave.
That's the potential bottom line impact, yes.
Yeah.
It's a significant financial risk that HR and finance departments need to factor into their budgets immediately, especially if they previously just relied on the UIA to cover the entire period of parental time off.
Okay, that's a huge takeaway for businesses.
Absolutely. Employers need absolute clarity in their own updated policies about how those final weeks are handled. Will they offer a paid top-up, or will it be stipulated as unpaid leave? Transparency with employees is key here. Remember, the ruling guarantees the time off, but not necessarily full pay for the entire duration beyond the UIA limits. Though, as I said, market pressures often push companies towards providing pay.
It's complex, certainly. But stepping back, this ruling does seem to push South Africa much closer to sort of global best practices on inclusivity and shared care, doesn't it?
It really does.
Yeah.
It's a major signal about aligning with modern, equitable labor standards seen internationally. It powerfully reinforces the dignity of all kinds of family structures,
Yeah.
and it directly challenges those, very deep-seated societal stereotypes that have historically tied caregiving almost exclusively to women.
Yeah.
It forces a really important national conversation about what shared responsibility actually looks like in practice and what genuine support for modern families entails.
So, wrapping this up for you, our listener, what's the big picture here? This ruling is undeniably a progressive leap forward. It elevates the rights of all parents, adapting the law to fit how families actually live today, regardless of gender or how they became parents.
Exactly.
Yeah.
It's a strong statement on equality, on shared responsibility.
Yeah.
But maybe here's something to think about. The court's intention is clear: immediate equity. Yet it also explicitly calls for collaboration and dialogue among stakeholders over the next 3 years while Parliament rewrites the laws. What does that need for ongoing talk tell us? Does it hint at maybe the resistance or the sheer complexity involved in shifting those really ingrained societal views on who provides care? And thinking very practically, if those verification processes for shared leave the ones we discussed needing proof and communication remain a bit fuzzy or lack a central database, what vulnerabilities might emerge? Could we see challenges in enforcing the leave properly? Or could misuse of benefits become a more common issue over these next 3 years before the final legislation is in place?
Definitely some important questions to ponder as everyone, employees, employers, government, navigates this new, intricate landscape, balancing legal duty with cultural evolution. Thank you for joining us for this deep dive into South Africa's changing parental rights. We'll see you next time.